Good evening. Welcome to another lesson on strategies number 13, 14, and 15. This is going to be one of the longest presentations so far because I have decided to combine the three strategies. I will start with the strategy number 13, then I go to number 14, and then through number 15. Strategy number 13 is prosecution. This strategy is closely related to the strategy on stern disciplinary action. Once the stern disciplinary action has been taken and the suspect employee is dismissed from employment, then the management should consider handing over the same to the state authorities for prosecution. The disciplinary action should not be the end. The end should be prosecution by the state. Prosecution will be in two stages: criminal prosecution and then civil litigation. Fraud or corruption offenses are against the state because they are criminal in nature, and therefore they are prosecuted as per the provision for criminal proceedings by the state employed prosecutors. The victim and the investigators as complainant and expert witnesses on the other side. Mistakes organizations make when it comes to prosecution or when it comes to taking stern actions against suspected wrongdoers. The following are the mistakes organizations make that lead to acquittal of the suspects, and as a consequence, they suffer counter litigations for wrongful dismissal and defamation, which again lead further to the organization making losses in terms of damages awarded by the court. Number one of such mistake is organizations consider engagement of forensic investigators to correct evidence as an unnecessary overhead, and therefore just hands the case in for prosecution without proper gathering and correction of forensic evidence. Number two, they just leave the case in the hands of the government prosecution or prosecutors without proactively following up. Organizations must hire a lawyer and a certified forensic investigation professional to work with and support government prosecution for effective delivery of evidence to court in support of the case or in support of prosecution. CIP will deliver expert testimony based on his or her investigation and correction and analysis of evidence. I know of cases where organizations lost millions of cash to fraudsters. They were discovered and taken to court, and due to the above mistakes, they were acquitted due to insufficiency of evidence, and they later countersued their employers and were awarded millions of cash, and the employers ordered to reinstate them. What will you do if it were your organization? Very unfortunate. You have lost millions in terms of the actual fraud, and because of negligence and lack of follow-up, you lose the case, and then the suspect comes back for more millions on top of the fraud, the frauded amount. Recommended stages of litigation. The following are the stages I do recommend for maximum deterrence to those who might be thinking of perpetrating fraud or corruption. Number 1, criminal prosecution. Number 1 is criminal prosecution. This will lead to criminal conviction and the sentencing. The prosecution in this case provides adequate evidence that proves beyond reasonable doubt that the fraud did occur and the suspects in court are responsible. If they are proved guilty before the court of law, they will be imprisoned as per the criminal guidelines touching on fraud and corruption. They can be sentenced to many years in jail. Civil litigation. The judgment in stage 1 above, criminal investigation, should be used in civil litigation for the recovery of the proceeds of fraud and corruption. This is where the forensic investigator can be of great help to an organization. CFIPs are trained to trace the proceeds of fraud and the corruption to banks, hidden assets, close relatives, and abroad. That is, proceeds stashed in tax haven countries outside the country, the crime scene country. All this can be brought down into personal statement of affairs that will show the court the amount that must be recovered in terms of bank accounts and assets seizures. This litigation will deprive the convict of all the amount defrauded, so that after the sentence full term, he or she, when she comes back to start, she will have to start from zero. This will send a tough warning to could-be fraudsters that they will stand to lose badly if they attempt and are caught and convicted. Consistency. All suspects of financial wrongdoing must be forwarded to law enforcement for prosecution regarding of their position or political affiliations or relations to the powers that be there within the firm or without. Partiality in this matter, all different treatments of of suspects will encourage such acts instead of deterring them. Secrets to effective prosecution. The following are the secrets to winning strategy in any white-collar crime prosecution. Number 1, hire a forensic investigator to gather adequate evidence, and if his findings indicate that there is not adequate evidence, to not proceed to prosecution. It is a huge mistake to go to court with insufficient evidence, since there is like 100% probability that the third case will fail owing to the criminal ruling principle of proof beyond reasonable doubt. Whoever alleges must prove the facts. That is the principle. So organizations must go to court only when they have been advised by their forensic investigator, a CFIP, that the evidence is sufficient to support the prosecution. Number 2, hire a competent lawyer to advise your organization all the way. Having qualitative legal advice is very critical in court cases. The counsel will ensure that no mistakes are committed and the prosecutor is well updated with relevant evidence. Number 3, to not miss any court hearings. All prosecution must pay oral court summons to testify. Number 4, provide all the information required by the court. Ensure that all relevant evidence is provided to the court through the prosecutor. In any case, evidence is power. Courts do not and will never decide cases on hearsay, but verifiable and undeniable evidence. Conclusion. Since no sector is immune to corruption, it is necessary that the states acknowledge the particular role and the vulnerability of justice sector institutions in regard to corruption, and engage in continuous efforts to create independent, ethical, and accountable justice sector institutions. To assist organizations in confronting the problem, the UN is taking a variety of approaches. It is examining corruption in the judiciary and other justice sector institutions in detail, looking at the organization level, including separation of powers, mandates, processes, and at the individual level, including professional ethics, protection from interference, and training. Based on the analysis, the UN seeks to identify good practices and the means to address and mitigate the risk of corruption and promote integrity throughout all justice sector institutions. That is the end of my discussion on strategy number 13. Let us now move to strategy number 14, annual staff records reconciliation. Annual staff records reconciliation is strategy number 14, and this is one of the most important strategies in combating fraud and corruption, both in the government and the private sectors of the economy. I will now go into the details to explain what annual staff records reconciliation means and what it can do in terms of detecting fraud or corruption in organizations and government agencies. The annual staff records reconciliation must be done by all employers, whether public, government, or private organizations or non-profits companies, to stop payments due to ghost workers. Not just payments to ghost workers, but also ghost payments, because the workers could be there, but they are drawing payments from the organization which is not authorized. This kind of reconciliation will reveal that or detect that. This is strategy number 14. The board of directors must require their auditors to carry out this exercise annually to deter, prevent, and detect ghost workers and ghost payments. If the organization has the anti-corruption or fraud unit, then those investigators employed under such units are the right people to carry out this exercise every year and then give reports to the board of directors. I will now do some definitions to make us understand this strategy better. Ghost workers. I cannot take it for granted that all my listeners understand what ghost workers mean. Technically speaking, a ghost worker or a ghost employee is someone recorded on the payroll system but who does not work for the organization. The ghost worker or ghost employee can be a real person who, with or without their knowledge, is placed on the payroll, or a fictitious person invented by the dishonest staff trying to defraud his employer. Ghost payments. Ghost payments are those payments that are paid to existing staff but over and above the authorized rates. These are overstated salary and related payments. Ghost workers and ghost payments are multi-million-dollar schemes. These cost organizations and governments millions and millions of dollars per annum. Look at the example below. Mozambique has 30,000 ghost workers on payroll. This was reported. It was reported the government of Mozambique had 30,000 ghost workers in this civil service payroll. It is say that some were paid for jobs they haven't done, others were dead or fictitious. The fraud cost an estimated 250 million or 200 million pounds over 2 years, according to the Civil Service Minister Kanerita Namashulwa. December 11, 2018, 12 p.m. by the BBC. Examples of ghost workers are A. Non-existent or created workers in the payroll. These are also referred to as fictitious workers. B. Really staff but dead or dismissed or retired but are still maintained on the payroll. C. Really staff but duplicated or tripled on the payroll so that one person earns salaries of 3 staff or more. I personally investigated fraud case where this was the main scheme for a period of 5 years, and as a result, the firm had lost millions. Human resource records. These are records related to staff, their employment history, promotions, demotions, transfers, and leaves. The list can be long. The main records relevant to the discussion under this strategy are: number 1, staff employment records. These contain the following information: A. Staff appointment letters with agreed rates of pay. B. Staff CVs and employment history, including disciplinary letters. C. Upgrades and promotions. D. Retirement dates and third notifications. E. Job performance evaluations or appraisals. F. Disciplinary warnings. G. Leave applications, just to mention but a few. Number 2, payroll records. A. Copies of employment or hiring letters indicating the rates of pay. B. Upgrades and salary adjustment notifications. C. Termination, retirement, suspension notifications that impact on the payroll. D. Statutory reductions, law changes. E. Copies of attendance registers. 3. Attendance register records. The information that can be found on the attendance registers or records are as follows: A. Absentee hours, including costs of absences. B. Bradford factor report options screen to view frequency and the duration of selected absences. C. Departmental hours variancy. D. Individual or department overtime hours. E. Length of service. F. Percentage of absency. G. Time allocation breakdown. H. Time card, hours worked. I. Vacations, including costs of outstanding vacations. J. Worked hours, including costs to employer. The above information will go a long way in helping in carrying out the staff records reconciliation. Staff annual fiscal count. I cannot complete a discussion on staff's record without reconciliation without touching on the fiscal count. There can be staff reconciliation without the fiscal count record. That cannot work. The fiscal staff count must be part of the reconciliation. It is better that the auditors or investigators carrying out this exercise understand and they do this exercise annually, and then combine reconciliation for external auditors to review as they do stock inventory. Organizations do stock inventory religiously, but they forget that the most important asset is human capital, the inventory of which must be carried with the same seriousness, carried out with the same seriousness. Staff inventory is even more important than stocks inventory, since it might also be used for staffing or identifying staff deficits or excesses. Staff fiscal count must be done by counting the individual staff one by one as they are at their workstations. Those on leave must be recalled for the exercise so that they are physically identified and counted. Annual physical count of employees is the best technique for verifying the total number of employees the organization or government agencies or a non-governmental organization has. Staff records reconciliation. This must be done by all employers, whether public, government, or private organization, whether business companies or non-business companies, to stop payment to ghost workers. The following are steps in the reconciliation. Number 1, get accurate employee fiscal count record. Number 2, get and ascertain the accuracy of employee records as per the Human Resources Department records or files. Number 3, get payroll and supporting documents. Number 4, compare actual hours worked with the payroll entries. Number 5, compare actual work done and the overtime pay as per the payroll. Number 6, compare rates as per human resource records or files and the actual entries in payroll. Number 7, compare number 1 and 2 and 3 and then highlight discrepancies if any. The comparison should be both monetary and the numbers of employees. And number 8, investigate the discrepancies and then take action or compile a report to the board. The following are the frauds that are most likely to be discovered by staff records reconciliation in a corrupt governance system. Number 1, names in payroll that are not supported by human resources records. Number 2, names in payroll that are not supported by employee fiscal count. Number 3, overstated rates of pay in payroll. Number 4, retirees still in payroll. Number 5, dead employees still in payroll. Number 6, names of actual employees included more than once. Number 7, overtime payments not supported by work done. Number 8, fake promotions and upgrades not supported by human resource records. Conclusion. As mentioned above, most companies don't have the exact count of their employees. It is against this backdrop that most corruption cases thrive. When an instance of a fraud has been detected, the perpetrators cannot be prosecuted because they were ghost workers. Such loopholes must be purged and sealed properly after thorough annual staff records reconciliation. This is the end of my discussion on strategy number 14, annual staff records reconciliation. I now move to strategy number 15, thorough pre-employment screening of recruits. This is one of the most important strategies in combating fraud and corruption, both in the government and the private sectors of the economy. I will now go into further details on strategy number 15. Employee screening. The screening I'm talking about here is the screening of employees before they enter the organization. That is stage number one, which is the most important. And then this type of screening will move to all employees to check on their backgrounds. But the most important in preventing fraud and corruption in organization is the pre-employment screening. And this is what I am going to discuss on this strategy number 15. Strategy number 15, pre-employment recruit screening, is one of the most important strategies in combating fraud and corruption, both in the government and the private sectors of the economy. It goes without saying that every time a business needs to fill an open work position, there are a few steps that need to be taken. The job description needs to be published online, for instance, so that the interested parties can submit applications for consideration. The employer then needs to sift through these applications, pick out qualified candidates, and set up interviews. Some employment processes consist of phone interviews followed by in-person interviews. And the interviews usually give the employer the information they need to make an educated hiring decision. But wait a second. The narrative outlined above is missing one of the core elements of any employment screening process, the background check. Think you don't need to run a background check to make the right hiring decision? Do you think like that? In this lesson, we will define the word pre-employment. We will look at ways through which the employer can achieve it, and it is been a fast one, and it must be done even if it has not been done in the organization before. We will start by first looking at the brief introduction. Employers face a number of human resource challenges. Recruiting the right employee for the right job is one of the most critical challenges, and the task has become more difficult with the global economy and a very mobile workforce. Employers can no longer rely solely on candidate interviews to make sound hiring decisions. Pre-employment screening is a process that allows employers to verify information such as education, prior job history, and performance. In addition, the screening process reveals important information about a candidate's prior behavior, which can help an employer assess the potential risk posed by the candidate. Prior behaviors can include substance abuse, credit history, and bankruptcy, driving records, and criminal convictions, and also civil litigation. Pre-employment screening is the investigation of potential employees' backgrounds to ensure that their claims regarding qualifications and experience are true, and also that they do not have a criminal history. Why pre-employment screening? This is important since it is more risky starting with a criminal instead of a clean person. A person with criminal record is most likely to start scheming wrongdoing right from day one in employment. underscore this statement. The person with the criminal record is most likely to start scheming wrongdoing right from day one in employment. His or her aim in joining the organization could be to steal, whereas that of a clean person would be to work for honest wages. I am not saying that the person that passes screening will remain good and honest forever. No, it will all depend on the following. Number one, implementation of the policies and strategies discussed in these lessons. Number two, the tone at the top and organizational culture and continuous staff motivation. All these three factors, implementation of policies and strategies discussed in these lessons, tone at the top and organizational culture, and also continuous staff motivation, will keep the clean and honest staff working for the organization honestly until retirement. Even dishonest employees can be kept working for an organization for many years until they retire with their dishonest tendencies by removing all reasons and opportunities to execute their evil plans. If that can truly happen, it does happen, then it will be easier to deal with an honest person from day one. While the honest employee will start by spotting loopholes, while the dishonest employee will start by spotting loopholes in the system. While the honest employee will start by spotting loopholes in the system and recommend amendments, the fraudulent employee will start by spotting the weaknesses and then plan to take advantage of them to steal as much as he or she could, and if not caught early enough, he or she resigns and runs away with the proceeds of fraud and corruption. And this do happen most often in most organizations. Organizations just come to discover that they have been keeping a criminal who has defrauded them big time only after he has resigned and ran away to another organization or flown abroad. Steps in pre-employment screening. The following are the main stages or steps to be followed. Number one, advertise and receive applicant CVs or resumes. Number two, shortlisting to remove those who are outrightly not qualified. Number three, scrutinize the CVs of the shortlisted applicants to extract the following information. A, employment history. B, academic and professional training. C, gaps in the whole history from basic schools to university. D, criminal records examination. Number four, embark on the actual screening using claims and information in stage number 3 above. Investigating employment history. This is the most important step as far as screening is concerned. Since it is likely to reveal reasons why he or she changed jobs. The main reason could have been notorious resign, or we sack you. Upon discovery of wrongdoing, many organizations ask their employees to resign before they are sacked after discovery of their wrongdoing by them. If they resign, the story ends there. The employee then goes ahead to state in the CV that he resigned from the employer. Was he or she dismissed, or it was voluntary resignation? If it is discovered through investigation that he or she was asked to resign, then that was dismissal in a polite way. Carrying out undercover investigation of claims on CVs, many shocking discoveries can be made that will surely lead to disqualification of some or all of the applicants before the final interviews. The traditional sending of letters to previous employers requesting for references or confirmations of employment does not work in discovering fraudsters, since the letters might run on a relative of the person being investigated. And what do you think the confirmation will be? You can just guess. Positive confirmation. Investigating educational professional memberships. Many job applicants give false information or documents to support their CVs. At this point, I think it is good to briefly outline the common types of non-official or illegitimate documents. Number one, forged or altered documents. Official, legitimate documents that have been altered in some way. Number two, fabricated documents. Documents fabricated to represent official documents from real or non-existent institutions. Number three, inside jobs. These are special cases because the documents are actually produced by institutional employees, usually for a fee. Inside jobs are factually impossible to detect upon initial review. What I mean to say here is that there can be an inside job whereby an employee is given a recommendation which is not appropriate, and then this will be forwarded in support of a CV or application for a job. This is not easy to detect from the initial review. It requires proactive investigation, steps and processes to discover this kind of vouchery. Number four, creative translations. Translations of foreign language documents that are not just inaccurate, but systematically misleading, tantamount to fabrication. Number five, degree or diploma mill products. The products of degree diploma mills are not in themselves fabrications, but in the academic study they purported to represent is certainly not proper. The above list is not exhaustive. It much depends on the creativity of the fraudster. The forensic investigation in this area should follow the following steps. Number one, analysis of the certificates to identify the institutions that are purported issuers of the same, noting the dates when they were issued. Number two, matching the information above with the CV or resume that was attached to the application for employment or admission, as the case may be. Number 3, personally visiting the issuing institutions. Do not write. Sending confirmation letters or asking for reference does not help, since there could be collusion from within the institution with the hold of the certificates, or the person you are contacting could be a relative. The person of interest could most likely be undercover for best and reliable information. The undercover investigation can plan investigator can plan to feast and attend their room in a meeting and then pretend like he is lost and just attended out of curiosity, and then talk to the graduates of the same year as the one indicated on the fraudster's certificate. Another technique is to seek ways of verifying the admission number on the certificate. Lack of internal investigative capacity. If there is lack of internal capacity to carry out undercover investigation of the educational and professional credentials, including employment history, please engage the independent professional investigators with good training and experience in intelligence gathering. Those organizations with the internal investigation sections employing CFIPs are already having capacity to carry out the investigation and need not hire external experts. Treatment of fraud suspects. If it is discovered that some of the applicants had provided false or forged employment letters or certificates, they should be forwarded to the police for arrest and prosecution. This is what will deter such behaviors in the future. They should not be left to go scot-free. The benefits of pre-employment screening. The benefits of pre-employment screening are as follows. Better candidates lead to better employees. Employers who utilize pre-employment screening as part of their recruitment process realize a number of important benefits. One of those benefits is a general improvement in the quality of applicants, which ultimately leads to better workers, higher productivity, increased quality, and lower employee turnover. Simply announcing to all applicants the intention to conduct background checks will discourage some candidates from applying. At minimum, candidates will be more likely to represent themselves honestly. Statistically, 51% of all resumes contain inaccuracies in employment, job performance, education, and educational achievement. Equally important, the announcement will encourage some high-risk candidates with criminal backgrounds to eliminate themselves, which saves time and money in the recruitment process. Conversely, the announcement does not discourage good qualified applicants who know their background check will not reveal significant problems. When businesses begin implementing pre-employment drug testing in mid-80s, the practice quickly discouraged drug users from applying for employment at companies who conducted the test. Drug users could only apply for work where drug testing was not conducted. Deploying pre-employment screening provides the same impact. As more and more companies utilize pre-employment screening, those who do not will become the employer of choice for those who have criminal behavior or at high-risk behaviors in their background. The return on investment for background checks is easily realized in turnover reduction. Background checking helps prevent the hiring of a problem employee, which will ultimately become a turnover statistic. With the cost of a third party provided background check generally less than a single day's pay, it is not hard to see a first hard dollar return, while in the longer term, benefits of productivity, quality, and increased customer satisfaction are being realized. Reduction in non-violent employee misconduct. Another benefit provided by the pre-employment screening is a reduction in the non-violent employee misconduct in the workplace. Non-violent employee misconduct can include theft of company or customer assets, fraud, drug possession or solicitation, and identity theft or other confidential information abuses. In addition to the obvious financial impact, these acts can result in lost customers, defrauded employee morale, and the company can brand and image destruction. Pre-employment screening can be an effective method for identifying applicants who have a track record of non-violent but damaging acts of misconduct in the workplace. Employment verification and reference checking can identify applicants who have a history of employee misconduct. While some employers may be reluctant to reveal this information, the courts have protected companies which provide true and accurate information about applicants to potential employers. It is safe to advise a potential employer that a candidate was fired for stealing if, in fact, that statement is true. Other forms of pre-employment checks can be utilized to determine whether a candidate has a propensity for theft or fraud. Credit reports, bankruptcy reports can be used to determine whether a candidate may be under extraordinary financial strain. That condition, combined with the appropriate opportunity, may lead to an act of theft or fraud. However, employers must use good judgment when denying employment based on credit history. If the position in question does not have the opportunity for theft or fraud, employment denial may be considered discriminatory. A candidate's driving record is an obvious consideration if the position requires the operation of company or customer vehicles, but frequent moving violations may also indicate a pattern of unsafe behavior or disregard for safety regulations. Knowing this may be important if the position involves operating machinery, equipment or machinery. Employment verification, reference checking, credit and bankruptcy reporting, driving records, and criminal conviction checks can lead to reduction in instances of non-violent but costly employee misconduct. Reduction in the risk of negligent hiring litigation. Negligent hiring is a legal theory under which employers are held responsible for injuries caused by their employees if the employer failed to take reasonable care in the employment selection process. The employer can be held liable if they did not know about the employee's history if it is determined that they should have known. An employer may be found liable if the employee injures a co-worker, customer, or a member of the general public, even if the employee is not acting within the scope of their job duties when the injury occurs. 3. The employers must demonstrate reasonable care relative to the position that is being filled. Although there is no defined list of jobs and the specific checks that are considered reasonable for the jobs, employers can follow some common sense guidelines. As a general rule, positions with a greater exposure to co-workers, customers, and the general public have higher standard of reasonable care. Positions of special organization or business company, such as caregivers or security personnel, have a higher standard for reasonable care. An employer can reduce their risk of negligent hiring liability by implementing a reasonable and a consistent background checking program as part of their recruitment process. The program should contain the following elements. Number 1, the background check should be consistent with the specifics of the job. If the position operates a vehicle, then a driving record check should be performed. If the position has little contact with others, then a rigorous check may not be required. Number 2, review the job application for gaps in employment. The applicant should provide reasonable explanation for any gaps listed on the application. If they cannot provide reasonable explanation, then an investigation is in order. Number 3, verify all employment and education claims on the application and the resume. Check all references that are provided. Number 4, document all reference and background checks that were performed. Make note of the references and employers who did not respond. Number 5, be consistent and follow the process that has been established. It is important to take all necessary steps in spite of time pressure to fill a position. 6, it is better to be safe than sorry. When in doubt, take the extra step and conduct a more thorough search. Not every state or country recognizes negligent hiring, and the standards for determining liability can vary from country to country, from state to state. Where employers have been found negligent in the hiring process, the financial penalties have been substantial and can include actual punitive damages. The most severe cases of negligent hiring have had judgments in the millions of dollars. Compliance issues. The Equal Employment Opportunity stipulates that employers may use arrest and conviction information and misdemeanor offenses in the selection process as long as they consider the whole picture of an applicant. The whole picture should include interview performance, education, work experience, job fit assessment results, as well as background screening information. The standards established the 4 criteria that employers should follow when reviewing pre-employment screening results. Number 1, determine whether the applicant is likely to have committed the alleged conduct. Number 2, consider the nature of the offenses. The employer should not implement a blanket policy against hiring anyone with a conviction. The significance of the act should be considered. Number 3, consider the amount of time that has passed since the conviction. The standard does not specify the amount of time required to pass before conviction is no longer relevant. In most cases, standard screening reports cover the past 7 years. Number 4, consider how the offenses relate to the nature of the job. It may be considered discriminatory to deny employment based on a conviction that is not relevant to the core responsibilities of the job. Employers should follow the standard criteria in a consistent manner across all recruiting and hiring activities to avoid potential discrimination. The Fair Credit Reporting Act is a federal law in the U.S. which governs the use of background screening for employment purposes. The rules apply to employers who use the third-party provider to complete background investigations. The main provisions of the Act include: number 1, employers must have permissible business purpose to order background checks. Pre-employment screenings considered a permissible business purpose by the Act. Number 2, employers must give applicants written and signed advance notice, gain their express and signed authorization to conduct a background check, and provide the applicant with a written copy of their rights under the Act. The summary of rights explains the course of action available to applicants if they wish to dispute the findings of the background. Number 3, when the employers plan to deny employment based on the background findings, they provide adverse action notification in the form of a pre-adverse action letter followed by an adverse action letter. The notices provide the applicant with instructions if they believe the findings are incorrect. Conclusion: according to the Alexander Hamilton Institute Employment Law Resource Center, 16,400 threats are made to employees, 723 workers are attacked, and 43,800 employees are harassed in the workplace each day in the United States. Employees who have a history of criminal behavior or workplace misconduct carry out a large percentage of these incidents. It is estimated that theft, espionage, and lawsuit stemming from poor hiring decisions cost U.S. businesses $18 billion per year. Poor hiring decisions can be minimized by implementing a recruitment process that includes work history, education, and reference verification or investigation, and a series of position-appropriate background checks or investigation. Background checks or investigation can include criminal history, driving record history, credit and bankruptcy history, and civil litigation history. It is important to implement a screening process that is consistently applied. The standard has issued guidelines to help employers utilize background information in the recruitment process, and the Act is a federal law which regulates the use of background information for employment purposes and guarantees certain rights to applicants. Employers can be held liable for actions of their employees if they have not taken reasonable steps to identify potential risks posed by the applicant. Negligent hiring lawsuits can cost a company millions in legal fees, as well as actual damages and punitive damages if the company is found to be negligent. Many companies choose to outsource some or pre-employment screening to specialized firms, and these must be investigative firms. Companies who choose a pre-employment screening provider should exercise due diligence to make sure they have the specialized skills and the knowledge required to perform all functions correctly and in full compliance with the EEOC and the FCRA Act. This is the end of my discussion on strategy number 15, and also the overall end of my lesson today, which has taken us through strategy number 13, strategy number 14, and a strategy number 15. I can see that there are no questions because no students were watching me online, and therefore I choose to hang up immediately and then wait until tomorrow morning when I will deliver another lesson.